Hello, and welcome to this LexisNexis webinar on everything you need to know about the California Privacy Rights Act. I'm Mike Swift. I am the Chief Global Digital Risk Correspondent for MLex, and I'm joined today by Lisa Sotto of Hunton Andrews Kurth. Yogi Berra once said, "The future ain't what it used to be," and I feel these days that's particularly true with privacy. During my first few years at MLex, we were always writing about privacy regulation in terms of this could happen someday in the future. But ever since the California Consumer Privacy Act took effect at the beginning of last year, I feel like we're no longer writing about things that are going to be happening in the future. We're writing about things that are happening right now. Last year, for example, we covered the actual political campaign that led to California voters approving Proposition 24, which enacted the California Privacy Rights Act. We're expecting Governor Newsom, very possibly as soon as today, to announce the appointments to the board that will run the California Privacy Protection Agency, which will be the first standalone privacy regulator in the U.S. When Lisa and I first laid out the plan for our conversation today, we're going to talk only about the CPRA, but events forced us to change that plan a little when news broke on March 2nd that Virginia had enacted the second comprehensive state privacy law. So Lisa is going to share her wisdom on that new law today. We may briefly touch on other developments in other states as well. But our time is short today. We want to be efficient. So I'd like to just introduce Lisa formally, and then we'll just jump into questions. Lisa Sotto chairs the Global Privacy and Cybersecurity Practice and is the managing partner, Hunton Andrews Kurth, New York office. Her practice focuses on privacy and cybersecurity. Lisa was named to the National Law Journal's 100 Most Influential Lawyers in America list. And I don't know of any greater compliment I can give than to say that when I'm having a problem understanding a particularly thorny issue in privacy law, Lisa is right at the top of the list for the people that I call. So it's really an honor to be able to throw a few questions at her today. And here we go. Welcome, Lisa.
Thank you, Mike.
So I don't think I've read a 10-case filing this winter that hasn't mentioned the California Consumer Privacy Act and the newly approved California Privacy Rights Act as a material business risk. Why are these laws important?
Well, you're right. These laws have dramatically changed the privacy landscape in the U.S., but it's not just the U.S. environment that's changed. There really have been seismic shifts globally in this space. So let's just rewind a bit for 10 seconds. So in 2018, the GDPR became effective, and of course that law became really the lodestar for privacy laws around the world, including in the U.S. And then following on the heels of the GDPR's effective date, the Cambridge Analytica issue really catapulted consumer data privacy to the forefront of U.S. social and political discourse. And it was this backdrop that created a landscape, I think, that was ripe for legislative action in the U.S. And along came the CCPA, which was absolutely groundbreaking because it was the first comprehensive general privacy law in the United States that veered from what had been our previously sectoral-only regime, and really from the CCPA's initial passage in, what seemed to me to be a bit of a stealth move, to the CPRA's approval in a ballot initiative during a pandemic. These laws have made headlines over and over again during the past 2 years, and they may well have the effect of spurring Congress on to pass federal privacy legislation.
Great. Can you lay out in broad terms the general requirements of these laws?
Sure. But let's start with the CCPA, and I would say there are three broad buckets of requirements under the CCPA. First, the CCPA provides for really the typical consumer rights that we see in data protection laws all over the world. We have the access right, the deletion right, a right to opt out of sale. This is a newer odd right, something we don't see in other data protection laws. And of course, this has wreaked a bit of havoc, and it's the reason we see do not sell link in the footer of many websites now. So that's the first bucket, consumer rights. The second bucket, I would say, is transparency, the need to provide various notices about your privacy practices. The third bucket is really about vendor management and the need to have contractual obligations in place where you are disclosing personal information to a service provider. And then I'll add a fourth bucket, sort of half bucket, with training and other sorts of procedural requirements. And then shall I go ahead and turn to the CPRA as well and tell you what's new and different there? Okay.
Sounds great. Yep.
All right. I'll roll right into the new law. So the CPRA expands upon the CCPA, and it creates new compliance obligations for those businesses that are subject to the law. And interestingly, some of these concepts are straight out of the GDPR. And when I first looked at the CPRA, I was circling page after page language that is, virtually identical to the GDPR. So there's quite a bit of that. So let me kick off, if I may, to some of the key changes that the CPRA brings. So first, there will be additional consumer rights. So with respect to sensitive personal information that is used to infer characteristics about the consumer, there'll be a new opt-out right. And that's a very, very important caveat, by the way. Sensitive personal information used to infer characteristics about a consumer. Second, there'll be a right of correction. This is a right that is found in most data protection laws all over the world. And then there's a new opt-out right, and that's the right to opt out of sharing of data. And this is specifically in the context of cross-context behavioral advertising. So that's the focus here. Second, there's more transparency built into the CPRA, so companies are going to need to update their privacy notices. And I'll just point out one very significant issue here, which is that a business is going to need to include in the privacy notice the length of time that it intends to retain each category of personal information, or if they can't do that, then the criteria used to determine the retention periods. And I think that's a big change. Third, the CPRA introduces a new concept of necessity and proportionality. So a business's collection and use of data needs to be reasonably necessary and proportionate to the purposes for which it was collected. This is not a new concept globally, but it is certainly a new concept in the United States. Fourth, contracts. Well, we had enough trouble getting service providers signed up to the required provisions of the CCPA, and now we are going back to the drawing board, and there are more contracts that need to be added to the mix. We're going to need contracts now with contractors and with third parties as well as the contracts with service providers that already are in place. And then we're going to see new regulations, and they're going to tell us what to do with respect to audits and risk assessments. We're going to need, in some circumstances, to conduct audits and risk assessments. And then also, the new regs are going to tell us how we're going to be managing access and opt-out rights with respect to automated decision-making and profiling. So I'll stop there, Mike, because we could go on for hours about the granularity of these of both of these laws.
Yeah, there's definitely a lot to unpack there. We mentioned that the board of the new California Privacy Protection Agency could be named as soon as today. We think it'll definitely be named by the end of this week. What is significant, do you think, about the creation of the first standalone privacy regulator in the U.S., and how might enforcement change under the control of this new entity?
Well, it's clearly very significant, but I want to point out that we shouldn't forget about the fact that California had the Office of Privacy Protection, and that was led by the indomitable Joan McNabb. That office was disbanded in 2012 as a result of budget cuts, and now here we are again. So California really was ahead of the game even then. So now we have this new regulatory body that is going to be responsible for enforcing and implementing the CPA and CPRA. I don't know whether we're going to end up calling it the CCPA or the CPRA or have 8 letters in there. I don't know. We'll determine that, I suppose, over time. But certainly having an agency that is singularly focused on this area will increase the chance of privacy enforcement in California. And there'll be more enforcement resources that are available to the new CPPA. We really have an alphabet soup here. So, right now we have yet to see much enforcement activity from the Attorney General. And, I'm guessing that in part is a result of the 30-day cure period that exists. We do know that a number of 30-day notice letters have gone out. Some of them have focused on the lack of a do not sell link on websites. And so I think this is really, this 30-day cure period is driving the lack of visible, at least, enforcement in this space. And so, we await the first enforcement action, and it may come from the AG, or it may come from the new Privacy Protection Agency, California Privacy Protection Agency.
Great. We know that enabling regulations are key to a new law like this. And what types of CPRA regulations are we likely to see, and when do you think we could expect to see those?
Yeah, so there are new regulations that will need to be promulgated, and those are going to be, I think, really interesting to parse when they come out in draft form and then obviously final form. And we'll see regs, we're expecting to see regs on a variety of topics. So we will likely see regulations on new consumer rights requests, like the right to limit use of sensitive personal information, the right to opt out of sharing. As I mentioned previously, we'll certainly see regulations regarding audits and risk assessments, as well as automated decision-making and profiling. And by the way, I'll just note there, automated decision-making was not a concept in the United States, very much a European concept, and embedded not only in the GDPR, but also in the EU Data Protection Directive before that. But we have not really had this concept of automated decision-making in U.S. law, so this really is new to us here in the U.S. So, as to timing, while the Attorney General can begin the rulemaking process, the CPR's rulemaking authority transfers to the CCPA. That authority beginning the latter of July 1 of this year, or 6 months after the CPPA notifies the Attorney General that it's prepared to begin rulemaking. And new regulations need to be adopted by July 1, 2022. And I think that's great because we will need time to comply. So this will give companies 6 months to implement changes in their compliance programs that would be required by the new regulations.
Right. Yeah, we're going to have this switchover period coming up that we're going to be living with for more than a year. Given the GDPR and what you're just calling this alphabet soup of privacy laws, what areas of compliance do you think that companies should really tackle first?
Yeah, it's a good question, hard question. You're right to point to sort of this hodgepodge of requirements in this space, and it's not just in the U.S., it's globally. And companies really do face a difficult challenge in seeking to develop global privacy compliance programs. Ultimately, I think the only way to handle the fragmentation is to sort of rise above the fray and craft a global privacy program that's based on some of the key principles that we see in nearly every data protection regime around the world. And, just to tick off a few, certainly transparency is one, and privacy notices, privacy rights. And we know, because they're in every law, with the basic privacy rights that are granted: access, deletion, correction, and the like. The requirement to impose security obligations with respect to personal data. Certainly, we've heard over and over that privacy and security go hand in glove. They do. And security is built into every major privacy law, whether in the United States or around the world. So, the way to tackle this is to really think about having a general framework that embeds these principles, and then also ensuring that there's accountability built into this framework in the form of responsible privacy officers, policies and procedures, training, and the like. So, while there are a number of concepts that we can rattle off that would go into this sort of framework, it is important to create this corporate framework, and it seems like it's the most effective way to handle this alphabet soup of global privacy laws. I do want, if I may, Mike, to just mention, one area of compliance that I think is really causing quite a bit of hand-wringing in this space, and that is in the HR space.
Right.
So, businesses have done a good job of getting a compliance program in place in the non-HR context. But in the U.S., we are not accustomed to having HR data governed by privacy laws. So there really is some angst around the now new need to build a compliance program around HR data. And this is now coming home to roost because the moratorium ends for HR data and for B2B data. I'll mention that as well. Again, something we're not used to doing in the U.S. On the B2B side. So the difficulty is that companies need to boost their existing programs now to ensure compliance with the CPRA. But for HR data, they need to start from scratch, and they need to build a compliance program to comply with both the CCPA and the CPRA for HR data and for B2B data. And particularly for HR data, this is just a massive undertaking, and it holds particular challenges that I think are unique to the HR space. So, for example, businesses need to figure out how to comply with access requests from job applicants, from employees, from contractors. And given the fact that there are very limited exceptions to access requests, businesses are going to face the difficult questions that they'll need to tackle about what to turn over. Because in theory, they could be required to provide every single email that involves the requesting employee, and even system logs, for example, that include the employee's system ID. And we certainly anticipate that this right is going to be used by employees as a type of pre-litigation discovery. Back to you.
Could you talk, just to expand on that, because I've really struggled with understanding the HR aspects of these laws myself. I mean, what is the timing for this? There was like an exemption period, right? But that's going to be going away at some point.
That's right. There was a moratorium in place for HR data and B2B data, really because these are entirely new rights given to these classes of individuals in the United States. We really, aside from some pinpointed rights, we really didn't have privacy rights applying in the United States to employees as a class. Of course, there is HIPAA, the HIPAA privacy and security rule that applies to employees, but not quad employees. Instead, as patients or members of participants in health plans. So these really are this is a very, very new framework with respect to providing these rights and obligations with respect to HR data and in the workplace, and then also B2B data. So data that you might collect about vendors, for example, even name and email address of a vendor who's a California resident would be subject to the protections provided by the CCPA and CPRA.
Right. Okay, great. So earlier this month, we had a bit of a privacy bombshell in that the Virginia legislature and the governor signed into law the Consumer Data Protection Act for Virginia. And could you talk a little bit about how this law is different from the two California laws we've been talking about so far?
Yeah, absolutely. So Virginia was indeed the second state to enact major privacy legislation. And let me just say, the most astounding thing, part of all of this, in my view, was that passage of this law wasn't even the top story in every privacy trade publication the next day. I was really stunned to see that. I think maybe we're starting to think of this as a little bit ho-hum and same old. And certainly we're going to see dominoes fall in other states as well. So that was interesting. So as to substance, so let me hit the substance of the CCDPA a little bit. I have to keep all of these initials in my brain. So the VCDPA really closely echoes many of the concepts found in the GDPR. Personally, I find this law to be quite well crafted. It is streamlined. It's elegantly short, I would say. It's not short, but it is streamlined, and it provides a flexible approach to data protection. And by that, I don't mean less stringent. I just mean flexible. So I want to make sure that I'm not misunderstood there. I think this is going to be a tough law to comply with if you're subject to it, but there is flexibility built in, which I think is really helpful to businesses. The law provides a comprehensive framework for the processing of personal data of Virginia residents, and it becomes effective January 1, 2023. So we're going to be very, very busy until then, getting into compliance with the California rules, the new California rules, watching out for those regulations, and then now the Virginia law as well. So let me hit on some of the key concepts in the Virginia law. I think they're worth a little bit of time to go over. So first, applicability. So who does the law apply to? Well, this law is going to apply to fewer businesses than the CCPA because there is not a general revenue threshold like there is in the CCPA. So most businesses that are subject to the law will be subject to the law because they process personal data on an annual basis of at least 100,000 Virginia residents. Okay, so that's an important distinction from the CCPA. The law uses the terms controller, processor, and really a number of the terms used in the GDPR, which I have to say I appreciate because globally those are terms that we see really all over the world. And so we understand what that means as a general matter. Of course, the definitions are different, slightly different in every law, but not very different. And we have a good understanding now, having spent years now working through the GDPR, what those terms mean. So importantly, the law contains an exemption for HR data and B2B data. And of course, we just talked about how challenging it's going to be to comply with respect to HR data in California. So this is a reprieve really for businesses who can, now we can focus only on the CCPA with respect to HR data and B2B data. So with respect to consumer rights, the rights, while somewhat different, do closely align with the rights that are granted to consumers in the CCPA and CPRA. So we have a right of access. Consumers have a right to obtain a copy of their data. We have a right of correction. You have a right to correct inaccuracies in your personal data. There is a deletion right as well, just as there is in the CCPA. There is a limited opt-out right, a little bit different from the CCPA. Here, consumers have the right to opt out of processing of their personal data for targeted advertising, for the sale for monetary compensation of personal data, right? So that's different from the CCPA, which is monetary or the valuable consideration. This is just for money. And they also, consumers will have a right to opt out of profiling to the extent there will be a significant effect on the consumer with respect to decisions made for profiling purposes. So a little bit different opt-out regime there than in California. What is, I think, broader than the CPRA is the opt-in consent requirement for sensitive data, for the processing of sensitive data. This is not limited in the same way as it is in the CPRA. So here we see a broader right in Virginia. Let's talk a little bit about some of the data controller obligations that are in the Virginia law. We see in the Virginia law a collection limitation requirement. This is really straight out of Europe and every other data protection law around the world that mimics the GDPR, and there are many of them. So there's a limitation on collection of personal data to that which is adequate, relevant, and reasonably necessary. There is a purpose limitation. You know, these are just terms: collection limitation, purpose limitation. These are terms that we see over and over and have for 20 years in the data protection context. There's a data security obligation. There is also an obligation to push out a privacy notice. I would say that this requirement is more flexible than in California, and we can avoid some of the awkward and prescriptive language that's required by the CCPA when we're thinking about Virginia. We have similar contract requirements. We have to have contracts in place, again, with data processors. And here, under the Virginia law, we will also need to conduct data protection assessments for certain processing activities. I'll just finally note that there is no private right of action in the Virginia law. The Attorney General has the exclusive authority to enforce this law. So it's going to be an exciting couple of years ahead.
Well, that's for sure. We have only a few minutes left, but maybe we could talk a little bit about other states as well. I know at MLex, we're right now, one of my colleagues is covering a public hearing in the state of Washington on the Washington Privacy Act. Which state bills do you see as being most problematic from a compliance point of view?
Yeah, this is so important, Mike. I mean, this is what we're watching so closely, is what is happening in other states, because we could end up in a situation like the breach notification laws where we have 54 breach notification laws in the United States, the 50 states plus Guam, U.S. Virgin Islands, Puerto Rico, and D.C. I hope we don't end up in that situation. Those are much easier to manage where we have that sort of patchwork, because they're really very, very similar here. We already have two laws that are really quite different from each other. So there has been quite a bit of state legislative activity. There was a lot in 2019, but that came to a screeching halt last spring when state legislatures were really singularly focused on managing the pandemic. And now we're seeing an uptick in activity, and state legislatures are picking these bills up with gusto. We're keeping our eye on Washington, as you noted, as well as New York. And then there are some other states that I would say haven't really been on the radar screen, but that are really coming into sharp focus now, like Florida and Oklahoma. So to your second question about what's problematic, rather than point out which bills are most problematic from a compliance perspective, I would say that any bill that contains highly prescriptive requirements is ultimately going to be problematic because it will become impossible to design a privacy program that complies with multiple states' disparate and granular requirements. So we really, really need to watch that. And of course, I'll just end with this, the solution here. The solution would be for states to enact more flexible laws if we're going to take the state route, like the Virginia law. But of course, the real solution is for the federal government to step in and pass a comprehensive and preemptive privacy law. So we're really looking for that. I will end there. Thank you.
And we've pretty much exhausted our time, but I'd probably be remiss if I didn't ask you for your opinion on a federal law. I mean, do you see anything coming anytime in the near future there?
Crystal ball. I'm never good with crystal balls. I think there is a possibility, particularly if states, if we do see this domino effect of states passing their own privacy legislation, which really will make it extremely difficult, if not impossible, for businesses to truly comply with the law. So I think that the likelihood will increase as we see more state legislation come through. I do think there's real focus on this area. Certainly, the pandemic sharpened the federal focus on this area because there was a real understanding of the need to protect privacy and security with respect to health data. So I think there's a good chance of it. Of course, Congress has a lot of other things on their plate, so maybe arguably more important. So hopefully this is not too far behind.
Great. Lisa, thank you so much for sharing your insights. I thought that was great. We were trying to give people a really compact, valuable 30 minutes of information. I think we definitely got that from you, and I know I learned a lot, and I really appreciate the time.
Thank you so much, Mike. Appreciate it.
Take care, and thanks.